And elect Tom as a voting member, and Dale, should we? Are we missing two or just one? Feels like we're missing at least two people. We got some background noise going on someplace.
A little bit, yeah.
There's a little grandchild that I'm supposed to be babysitting for.
Maybe you'll need to mute unless you need to talk.
Yeah. We're going to try and get him in the other room.
No, I wouldn't do that. Then you can't babysit. How do you babysit from the wrong room?
I'm delegating it to my wife, Stephanie.
Yeah, there he is.
Thank you, Stephanie.
Oh, look at him.
Hey,
Hi.
Okay,
Mouths
so
of babes.
we'll call the meeting to order. Do we have anyone? We don't have any minutes from the last meeting, CJ?
Not yet. Heather's still wrapping them up, so we should have those ready to go for you for the next meeting.
For next week?
Minutes.
We realize
You got
there's
it.
only a week to the
Before
next
that,
meeting.
of course. That's right. Yep, they'll be
And,
going out with the agenda packet.
So do we have anybody waiting in the privilege of the floor?
We just have one person in the waiting room, and I believe that they are here to speak about the board appointment process.
So nobody has registered for privilege of the floor?
There was actually somebody who did ask to speak this evening, but I do not see them in the waiting room. Heather let me know that there were some people planning to watch tonight regarding the short-term rental local law as well. So I don't see them in the room though.
All right, then we'll move right along into the local law, the short-term property rentals. And what was your idea, what we wanted to do? Was Guy gonna give us some guidance, or were we gonna discuss it first? Were we gonna ask you questions?
Yeah, this was an opportunity to just tie up any of the loose ends that you felt were still hanging as part of this local law. And I know there were some concerns about that the board had expressed about the local law being a bit punitive. And I thought that it might be helpful to have counsel here to maybe address some of those concerns. So I can do a screen share, or Guy, if you'd prefer to do a screen share, whatever works best. We can just go through those comments.
I would suggest you do the screen share, so we all make sure we're looking at what you have as the most recent version, and then where there's legal, where there's legal questions, I can certainly provide input. And so, there was actually not too long ago, a federal case handed down on short-term rental regulation arising out of Lake Placid in the town of North Elba. And somebody literally filed like a 12-count federal complaint regarding equal protection impairment of property rights due to a short-term rental regulation. Most of it was thrown out. Some of it survives. There's a fair amount to go through. But again, you're probably better with a simple licensing process than a full-blown zoning regulation based upon what the federal case has said. But with that said, we're still drafting this thing. So what its final form will take is obviously a matter of input and then a final determination by the town board.
Absolutely correct. So do we want to go through it? Did we keep track of the questions that we brought up at the last meeting, CJ?
Yes, as far as I know, I took the comments and inserted them into the documents so that we could go through them and everyone could see them all at once. So hold on just a moment. And for some reason, screen sharing doesn't seem to be a thing all of a sudden on my computer, which is exciting. Okay. Great. Okay. Hold on just a moment, everybody.
While she's looking that up, Guy, could you briefly talk about some of the things that the court threw out as saying as were unreasonable, just so we have an idea?
I haven't fully analyzed the case, and I can pull it up and tell you what some of the holdings were. Let me do that. I have to find out where it is. Bear
Okay,
with
so the
me.
bad news is someone else is gonna have to share this link because I either have to quit out of Zoom. I reinstalled my entire OS this weekend, so apparently I didn't give Zoom the proper permissions, so.
Did you move up to Windows 11?
No, she's probably using a Mac.
I am using a Mac.
There you go. That's why it's not working.
Oh, cold, that's cold.
For that, I
Anyway,
think
well-
you just got to take the time to log in and out again.
All right,
That's
hold on.
not
Well, I don't
easy.
want to ditch you guys. All right, hold on.
Oh, look, I see some.
Okay, so hold on. Maybe it's, oh, look at that. I didn't need to refresh. Okay,
Hey.
here we go. All right, all right. Okay, thank you. Bearing with me here. Okay, sorry. I'm interrupting what Joe was asking.
Well, why don't you just go forward, because I have to pull that case up and look at what I highlighted. And I know it's in an email, and I think it's in a folder regarding short-term rentals. So
Okay.
maybe we can sort of do that as an overview at the end, or you can wait for me a split second to get out of exit full screen and dig it up.
Okay.
So CJ, the copy that I have on my tablet here is not the same copy that you just showed us. I mean, in
Okay.
other words, when I follow the link off the agenda, it brings me up to a copy that's number of 2022 instead of
Yes.
2020 crossed out 2021.
Yep, that's okay. Yep, that shows the one that's the PDF shows the clean version of it without any markup. Yeah.
I
So
was gonna
it's the
say,
same
I read
identical
through
thing.
this and I didn't see any markup stuff on it.
And I
Yep, it
found
was
the
just meant
case.
to be
If
clean.
I also just pulled up that case, if you want me to do a real quick overview.
Yep.
So, because it sort of sets the parameters of the playground, so to speak. And part of the problem is that, okay, so let me just go through it. First of all, the thing that was very surprising about this is that it was a multi-count federal complaint alleging a number of federal constitutional violations ranging from equal protection to due process, substantive due process, property rights, 1983 claims and the like, as well as related state claims. And the parties fully briefed the issues, and the court resolved the matter without oral argument, which is very unusual. So that was my first red flag that something's going on here. And you really have to understand the nature of what they drafted and how they wrote their regulations, because some of it has things with common and with what we have, and some of it went a little bit farther because they created per zone regulations. So the first claim, and this is really summarizing a 24-page decision with lots of cases in it. So, and I just read it today. But the first claim was an equal protection claim, and the court said these allegations make plausible the plaintiff's claim that short-term rental law creates distinctions between similarly situate owners of short-term rental properties without a rational basis. At this preliminary stage in the litigation, such factual allegations are sufficient to state a class of one equal protection cause of action. The court denied the motion in that respect. The next claim was a Fourth Amendment violation for an unreasonable search and seizure, because in order to get the permit, you had to allow a warrantless inspection whenever warranted. And the court found that they stated a valid claim that the short-term rental ordinance violated Fourth Amendment rights because it required warrantless searches of property as a condition of maintaining a permit to rent and own their property. Although the court acknowledged that discovery may reveal some significant defenses about this claim, such as circumstances that compel the need to search without waiting for warrants, but the court has to deny dismissal of that claim at this time. There were multiple due process claims, and I'm just going to read you some of the highlights using the court's own language, because I don't think I'm in a position yet to sort of extrapolate this into some quote unquote bright line rules. The court determined, however, New York zoning law appears to take into account the somewhat intuitive concept that a property owner necessarily expects the uses of his property to be restricted from time to time by various measures newly enacted by the state in legitimate exercise of its police powers. And they cite a bunch of cases. Accordingly, under New York law, a landowner has no vested right to the existing zoning status of her property unless she has made substantial expenditures in reliance upon such zoning status. As plaintiffs have failed to adequately allege a federally protectable interest in the unlicensed renting of their homes for periods of less than 14 days, their substantive due process claim is denied. They do, and I'm jumping around, so they do allege, however, that they relied on a long-term practice in the region of short-term rentals in deciding to purchase their properties, and that short-term rental law undermined those calculations. The court concludes that discovery would be necessary to determine whether plaintiffs have a protected property interest in short-term rental income, and in that sense, plaintiffs have alleged facts to make plausible their right to relief in this respect. The court recognizes that courts in this circuit, being the Second Circuit, New York, have not determined that the right to rental income is a protected property interest. The court notes that the purchase and ownership of property does not immediately convey an unassailable set of rights that are immune to regulation. However, making all inferences in plaintiffs' favor, the court finds that the plaintiffs have alleged that they purchased property that had customarily been used for the very purposes they intended to utilize it, and that defendants subsequently instituted regulations which undermine their ability to make use of the property in the intended way. The court must therefore find that plaintiffs have alleged sufficient facts to make plausible that the short-term rental law implicated a protected property interest. So the court hasn't ruled on that issue. What the court did was say, in this type of motion, we have to grant all inferences to what the plaintiffs allege. And giving an assertion and modicum of truth to everything they allege, they can stand on what they've pled and will have to proceed further in this case. So the court found that the plaintiffs failed to allege that the ordinance is not rationally related to a legitimate governmental interest. The plaintiffs are correct that the ordinance does not treat all properties the same, but that does not mean that the ordinance in question fails to create a scheme that addresses the entire jurisdiction. It talks, therefore, a lot about deferring to the underlying legislative determination and the court's duty to just determine if the rental ordinance is related to a legitimate government interest, which it found that it was. This law also had a 90-day limit per year on how off on your total rentals over a period of time in some of the districts. And that was the basis for a substantive due process violation. And the court held that the defendant, they must show that the town's action in depriving it of that interest was so outrageously arbitrary as to be a gross abuse of governmental authorities, such as it is. And they dismissed this claim, saying the plaintiff's allegations here that the law was ill-advised, that there were better choices to make when regulating this, and they don't rise to the level of conscious shocking. So the court denied those claims. There was a facial substantive due process challenge to an as-applied version of the law. And again, the court said there's no outrageous or arbitrary behavior or gross abuse of conduct that has yet occurred that the court can rule upon, since that there is no facial violation of substantive due process or a rational or any allegation that there was no rational basis to the law, such being only conclusory. The court threw out that motion. Counts 6, 7, and 8, they basically dismissed claims that the law was vague. And the language there is sort of funny. It said the court will grant this motion to dismiss count 6. A reasonable term would understand that the word available means in this context readily obtainable, accessible. This law had you have to have a local person who can be contacted in case there's a problem. And the court said that's a matter of future interpretation. All the due process protections of it going to an enforcement officer to determine if there's a charge that should be filed or intervention needed. The court didn't find that process in and of itself was violative of due process or equal protection. In fact, The court found that the notices and the opportunity to be heard and the right to contest any charges that were filed were in fact hallmarks of due process, not proof of the absence of due process. But I'm summarizing a little bit, so bear with me. The facial due process claim, the court said they did not make a facial due process challenge, and that motion was dismissed. The court basically said under count 10 that a due process clause does not require a government to provide the exact same procedural protections for every deprivation of property or a liberty interest. The government simply has to provide notice reasonably calculated under all circumstances to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. So a lot of the right to be heard stuff that's in the law that looks like fluff is actually important. They threw out all the pending state claims. They did also find that a 1983 deprivation of rights claim could stand, and that would need a further look. They threw out all the state municipal liability claims, like I said, on state laws because they were simply redundant of the federal claims. The interesting part about this is that it's the Northern District of New York, which is the district court that has jurisdiction over Tompkins County, and the judge who issued this decision is a senior district judge. I mean, Tom McAvoy knows what he's doing. So this will take a fair amount of work. And what this is signaling is that these types of regulations are perfectly legal, but they can be drafted in an overbroad manner. And that landowners may have property rights in the rental of their home, but those rights don't make them immune from all regulation because you don't have vested rights in your existing zoning. Part of what this case stands for is the question of, is this a zoning issue or is this not? There's lots of situations where you have permits as opposed to zoning. And I don't mean special permits. But you can have a regulatory scheme that affects property rights and the use of property without it being a per se zoning law. In other words, zoning is not a panacea. It doesn't solve all ills. It is just one tool in the toolbox. So whether the town board ultimately decides that this should be undertaken as a zoning tool, a regulation, or whether it should just be a licensing scheme to try to make sure that to the extent that there's public rental going on, that the building codes and fire codes and adequate life, health, and safety measures are there. In some respects, those are a little easier to tie to the police power than is a pure zoning regulation. But again, until we have a sort of a final version and can pour it through this crucible, I'm not sure exactly how it would all turn out. But that's sort of a nutshell of what the issues are. So when I say that people literally make federal cases out of something and bring 15 count 1983 claims, what I'm saying is that literally happened. I shudder to think what it would have cost, what it has cost that town to file motion papers and briefs that resulted in a 24-page federal court decision that basically answered some questions on a preliminary motion, and 3 to 4 of the claims will proceed through further discovery. In other words, they've already spent $100 grand. So there's a fair amount here to look at. And fortunately, by going with more of a straight licensing system, as opposed to creating different regulations for different zones, the town has avoided some of this. It's not treating someone in R1 differently than someone in R2 as respects property rights. Though the court said they could, it's just some of the claims can survive. So I'll shut up now so we can get to actual nuts and bolts. And I can certainly distribute my highlighted version of this, but it's a tough read. If you don't understand some of the distinctions between due process and substantive due process and equal protection, it won't necessarily be easy to figure out. But interestingly, I'm attending a seminar tomorrow where this is one of the key cases that's going to be discussed. So I'll be able to get some input from NICOM's counsel on what they think this all means. So more updates coming.
So are we a little premature to be discussing this now since recent events have overtaken, or are we better off standing where we're at and discussing it at a future meeting?
Well, I don't think it's my place to answer that, but I think you're exactly where you should be. You're looking at all the options, trying to decide what works best, what seems fairest, and you're not at the point where you've cast anything in stone. No matter what you decide, another case is going to come along that might say, oops, you shouldn't have done that. What you'll do when that happens, if that happens, is amend the law to not try to become, the person who has the 24 brief explaining to you why you're right or wrong. But again, I think this is just information that informs how you would proceed. The town has already determined legislatively and otherwise that this is an ongoing issue, that there are land use impacts, both short and long term, including impacts on affordability of housing. And there are many, many studies, some going both ways, but the majority of studies of the impact on short-term rentals on local housing stock and the cost of local housing is pretty legion. There's some studies out of, Los Angeles and even much closer. I know that's a very different urban environment. But some of the studies are showing that what this is causing is it's making the rental market prices go up, and therefore the rental market is no longer becoming the hedge against the cost of bricks and mortar. So it's interesting how this is playing out in multiple places across the country. But if you go to like major planning schools like University of Chicago, UCLA, and a few others, you'll find that there are actually treatises being written on this problem right now and the effect it's having on land values and land use in a lot of diverse environments, rural and urban. So there is something here to regulate. What you have to do is temper those regulations to address specifically and to the extent possible only the particular harm or the danger or negative effects of this particular land use, and regulate it to the extent that you can without unduly impairing the landowner's property rights. And all of zoning involves the balancing of regulations against the property rights. So the analysis is zoning based, but the law doesn't have to be zoning based. So again, I'll be here for questions on subject matter that comes up, but this is a process, and I'll be happy. I think I had already, CJ, did I already send you this case?
I don't think so. And I know you're touching on it just like a teeny bit, but, do you think that there's, how the planning board kind of considered in the two approaches, right? The zoning approach as short-term rentals as a land use versus the approach they recommended, which was from the life, health, safety, kind of minimum registration requirement. Do you think that kind of puts the current version that we're considering kind of in a different, I guess maybe this is where it's getting into mincing words here.
To me, I think going in either direction is legal. I think one direction over the other, I think you have more hurdles to overcome on the zoning side of it. And I think that this case really is sort of like the bell cow, so to speak, because you're really dealing with Lake Placid is what you're dealing with. A community that for decades upon decades has had a vibrant short-term rental vacation-based economy, including because of the Olympics. So I don't think that everything that's here is in terms of the vested or potentially vested property rights translates one-to-one, but there are certainly some parallels with how the comprehensive plan regionally on a county basis and a town basis is promoting tourism as a big deal. If you're going to promote tourism, then you need things for tourists like accommodation, gasoline, goods, services. recreation, parks, whatever it is. In my view, wineries. But at the end of the day, I think either is there. It's a question of which one works better. If it's still new and the law is in flux, but the need to regulate something exists, I would personally go towards the non-zoning regulation first. In other words, dip your toe in the water, see what works and what doesn't. And then once the law starts to gel and you start to see the actual impacts of regulating this and where the hot button issues are, then you may have enough information legally and practically to try to integrate this into zoning in some way. But I think you can go either way. I just think the zoning will take a defter touch, because this case suggests that having one rule in the RA and another rule in the R2 might run into some issues. And I don't know what the expectations of landowners were, because the town traditionally hasn't done a lot of regulation of rental properties. The town really has regulated the number of dwelling units on a particular lot or within a particular building. I mean, the International Building Code doesn't really well address this issue either, though there are clearly some fire code and safety issues that probably will need to be addressed. If I rent out 3 rooms in my house, am I a hotel or am I a house? I don't know.
And what responsibility do you have to those who are renting those rooms to provide a safe environment? And that's what we're trying to decide, I think. And after listening to you, I would much rather see us go down a road where we're working on licensing schemes rather than zoning schemes, until we get to a point where the legalities of it are better defined. Licensing schemes are a lot easier to change quickly without long terms involved in board meetings.
I'm in agreement with Jerry.
Yeah, I am too.
My question for Guy is there any red flags in the draft that we've got right now that you're saying, wow, that's coming a lot closer than I'd feel comfortable?
The only red flag, and again, I'd have to go back through the draft and sort of parse this down and break it down and see what pieces might most directly apply to the regulatory scheme that the town may be considering, because I think this is the 4th draft. But the only thing that really jumped out at me is we probably need to have a right to be heard before a stronger protection of the landowners' property rights, i.e. their right to be heard before we revoke the permit, because the permit itself or the license itself will probably, once issued, be viewed as a property right. So I think we'll have to be a little more careful about revoking for a violation, particularly when some of the ways of having it revoked could be rather subjective, i.e. what is loud music? Is 100 decibels of Barber or Tchaikovsky loud? Well, what if it's 100 decibels of, AC/DC or White Zombie? Some people would consider one noise and the other music, but they're both 100 decibels. So we really need to make sure that when permit revocation is there, that we have some safeguards and that we have very clear standards. And again, license revocation, we have some standards and some very clear objective safeguards that determine when a license is revoked, and the landowner should have the opportunity and right to be heard. And yeah, I agree with you, Jerry, that making sure that we have a safe environment for everyone in the town, whether they're pass-through tourists or permanent residents, is important. And that's the police power aspect of this. But what we really can't do is regulate the behavior of the renters. We can try to protect the space, but morally, should people provide a safe environment for their guests? Yes. Legally, define a safe environment.
Yep, that's the problem. And that's
Right.
where it's very easy to go overboard.
Yeah.
Because safety has many degrees. And there's no perfectly 100% safe environment.
Well, and at least in terms of dipping your toe in the water, a licensing scheme lets you tie concerns directly to things like building codes, fire suppression, emergency notification, things that are easy to rationally defend under the police power, as opposed to try to explain why someone on one side of the street can do it and on the other side they can't, merely because there's an arbitrary zoning line in between. To be clear, again, I think you can do both, but I think at this stage, with a first try at regulation, it might be better to start simple and then move towards complex instead of start complex and retreat towards simple.
I concur. Retreating's never a good idea if you can help it.
I won't make a joke about Tchaikovsky in the War of 1812 and what Napoleon learned on that line, but we'll move on to the particular questions that might arise as to this draft, and understand that as this case starts to drive the law a bit, and we see how it applies on a state level, we can then go back and refine some of the concepts a little more neatly.
All right, does anyone on the board have any questions or comment for Guy, or any comments about the local law as it's, as you've read it?
Yeah, and CJ,
Go ahead,
you wanna-
Larry. Go ahead, Larry.
I have a specific problem with item 4C. I don't think it belongs in the ordinance because it's talking specifically about family members, and it specifically says no money changes hands. So it's not a rental and it's not a short term. Now let's approach it from the why. If I own a house and my son's house burns down and he has to rebuild or rehabilitate it, I am definitely going to let him live in that house, that property that I own. I'm not going to be charging him anything for it. And that has, the short-term rental ordinance should have nothing to do with that. And what caused me to question it to begin with is it specifically says non-recurring single event visits or celebrations, owners' dwellings accommodate overnight relatives, or, without remuneration, or the 30-day period where no remuneration is generally provided is limiting to less than 7 days. We've had cases where people have had family come in from out of town to help with a medical situation for a long period of time. They would be required by this to get a permit from the town to have their family stay there for more than 7 days. Okay, or if the other situation where you have a son or a family member whose house burns down, you let them live in your property while they're rebuilding theirs. Again, that's no business of the town, no money's changing hands. It has no, to me, I'm not the sharpest chisel in the pouch, but I don't see where something specifically worded like that belongs in a short-term rental ordinance.
I agree 100%, Larry. It's
So do
none
I.
of the town's business.
I agree also.
None.
Yeah,
Well, I think that this is under exceptions, so some of this, I wonder if it belongs there as an exception, but certainly the last line in that, in number C or letter C, doesn't belong there at all.
I think having it in there at all confuses things and makes people think that it belongs in there.
I agree.
Well, I
again.
mean, it's under Article 4 exception, so you're making an exception for
It shouldn't even
overnight
be in there.
relatives
It's
and
not even a
guests.
question.
Yeah, I know it's under Article 4
It shouldn't even be
as
in
an
there.
exception, but if you read 4C without reading the title of Article 4, it's getting pretty specific about 5-day periods and 7-day periods and things like that. Why doesn't it
Right,
just
saying
say,
that you need to have my daughter come and visit me for 2 weeks and I need to get a permit for it in the town of Lansing is a little on
That's
the
right.
ridiculous side. And so
Yeah.
certainly that last sentence has got to go. I don't understand. I mean, I get confused by reading the rest of it a little bit since I'm not in Guy's profession, but the,
Well,
we do want to make sure that we have an exception in this thing that says that you can have someone come and visit and stay with you. And as far as I'm concerned, as long as no money's changing hands, the town has no interest in it at all.
Then that's all
This
need
is
to be,
short-term rental, and rental has a meaning here.
that's all that needs to be said, that residence by family members with no remuneration is accepted. And there's no need to get into it with the 7 days and the 5 days and.
Right. I would say relatives or guests. I mean, if you have someone come in who's not related to you, if, for instance, using your example, somebody's house burned down and I told them they could stay in my house with me for 2 or 3 months while their house was getting rebuilt or remodeled, what is the town, if I'm not charging them for it, what has the town got anything to say about it?
I agree.
Nothing.
I believe that in our definitions, we talk about households and unrelated people and all that. And I think we need to refer to that and say, that's what we're looking at. I mean, I agree that we should be able to have guests and families stay here, but I think in the other part of our law, what's the difference between my mom being a short-term guest and a long-term guest? However long I decide she gets to stay, really. And, she can stay for up to 5 days, but, after 30 days, does she become a long-term guest? When is she just a member of my household moving in versus being a short-term or long-term guest? And I think when you start looking at the definition of family in our law, we already allow people to have their family come and stay with them up to a certain number of people, depending on how big your house is.
So it shouldn't even be in the, it shouldn't even be in there. It shouldn't even be in the law. It
Well, I
shouldn't
think
even be a question.
I think the only question that really needs to be dealt with is what's the difference between me having guests stay for 2 weeks because they're coming in from Europe and they want to hang out in the Finger Lakes,
That's
and
not
me renting out a
It's
bedroom.
none of their business.
Well, what's the difference between that and me renting out a
Nothing.
bedroom?
Nothing.
I'm not talking about relatives. I'm talking about friends. What's
You're
the
not
difference?
Doesn't
renting it
matter. Your friends, your family. Christ, I got
What?
brothers from college that I could let him stay here for 6 months.
I understand.
What's the difference?
What's
Nothing.
the? Well, we have to have a
Nothing.
legal difference if we're saying that we're
Why?
doing. If we're saying short-term rentals require a license, but
It's
my
not a
guests do
rental.
not.
It's a rental. It's not a rental. It shouldn't
No
even be
money's
in there.
changing hands.
No, it shouldn't be in there. It
Okay,
shouldn't
so
even be
I
in
think
there.
you need to say something about family and
No.
guests where no money changes hands, so that you're defining when you're making a difference between a guest and a short-term rental.
All
Well,
it-
in order to
so
be a
this- So
landlord-
basically, this just goes back to the money then.
In order
My
to be a
point-
landlord, there has to be you have to be given a room in exchange for a fee or compensation. I don't know what monetary or otherwise is meant to mean, but that's pretty vague and could mean almost anything.
It
But-
seems to be, my point's been made. If that one line creates this much discussion, then it either needs to be severely modified or removed.
Yes.
Removed. You don't need permission from anyone else for somebody to stay in your house for a long time. It's your choice. Whether they give you money or not doesn't matter.
Correct.
It all goes back to money that the county's looking for a tax. That's all it does.
That's
Follow the
exactly.
money. Follow the money. It's not hard.
Actually, Doug, I think where this really came up was the idea of people renting out rooms that are not up to a standard that makes it safe in the case of an emergency. And I think
They're a
when we're
guest in
having
your house
people,
and something happens.
Mhm.
What do you-
And if I'm regularly renting out a room as a bedroom, the
Well,
windows
you're
have to be
not.
able.
This has nothing to do with renting out a room.
If
Yeah.
I'm regularly using a room as a bedroom, the windows
you
ought to
get-
be up to a certain size so people can exit them and things like that. I think we're just,
That's fine, but you're not renting it. You're lending it out to somebody, even if they're giving you money for food. It doesn't matter. It's none of your business. It's none of your business. We're going too deep here. This isn't that hard.
I concur. We originally wanted this to take care of garbage problems that got left there and make sure that we had somebody to contact in an emergency.
Right.
And
We're
we-
worried about people having too loud of music, and we're worried about people, bothering the neighbors. So if my guests are bothering the neighbors, come to me, tell me. Okay, great. Then fine, I'll take care of it. Why is this so hard? It's not.
I agree, Doug.
It's not
Not
hard.
everyone takes care of it, though. That's the problem, Doug. Not everybody. I could
But
go to
that's
you and
okay. Then you go to the police then, and then
Right,
it becomes
right.
then it becomes that. But it's not under regulation. Why is it under regulation? I don't have anyone. I have my daughter staying there. I'm charging her rent. I'm not charging her rent.
But even if you were, it should
So
be
it shouldn't
perfectly
matter.
legal. Right.
That shouldn't even.
If my
it
kid
shouldn't
gets
even
to
come
be
in.
18 years old and I say, okay, go find yourself a place. If you're going to stay home, you're going to pay me rent, which a lot of parents will do.
Then you give the money back to him anyway.
Only after he finds a place.
Yeah, you put the down payment on it. Big deal. It's their money anyway. Come on.
All I'm saying is
I think
that
we
it
got some
needs to
good
be,
sense here. I think it's
that
time
that
to
needs to
drop
be
it and move
rewritten.
on.
That needs to be rewritten or removed.
It's D. Get gone. Be gone with it. That's ridiculous. Well, that's my point. That's my opinion.
Well,
I
that
think the
takes
other
me
thing-
back. I agree that one should be gone, but it takes me back to the meaning of the word landlord, where a person or other member of the owner's immediate family in exchange for a fee or compensation, whether monetary or otherwise. Any property owner who offers a housing unit for short-term rental or occupancy. I mean, we're talking short-term rentals here. We're not talking just any old occupancy to person other than members of the owner's immediate family. Again, I think that all of that wording is designed to take us down a path that we didn't really want to go. We're not trying to keep people from being able to have anybody unrelated in their house, whether they're paying money or not. We're trying to make sure that we have a clean atmosphere, that the garbage is taken care of and not piled up on the porch when somebody leaves and left there to be a hazard to the neighbors, and that there's somebody to get a hold of in the case of trouble, and that the house is certainly worthy to be able to be lived in.
But now are we going to go?
Parking and taxes are being taken care of.
Yep. And of course, we need to collect that rental income tax.
Right,
Occupancy
for
tax.
short-term rentals, for VBRO. That's fine. I have no problem with that. I have no problem with it at all. But we're pinching lines here. We don't want to. This is silly.
I agree, Doug, and that's why I
It's
brought it
silly.
up.
It's absolutely silly. I mean, back to Joe, you brought up the point of windows and stuff like that. Are all the windows in your house ready to go? I mean, what's the difference between that and you? It's all of a sudden
the
it's
windows
on
in my
you.
house are definitely up to code on that.
I don't, no, this is a hypothetical, okay? So
No,
we're
but
gonna
I
go
think
back to, no, let me finish, for crying out
Okay.
loud. You're gonna go back to my house with the 1958 windows in it the first time, and you may not be able to get out a window. So what, are you gonna come down on me because all of a sudden my daughter's staying there? No. It was good back in 1958, but not now. Now I gotta upgrade my windows. It's none of your business. My house could fall apart. How many houses in Lansing are falling apart right now? I drive around a lot and I see them. Okay, right. Now they got to go through that. This is silly. It's silly.
The difference I'm saying is
I
between a
understand your
commercial
difference.
business. Okay.
It's not my commercial business. I'm not even including that in this.
Okay,
But
thank you.
you've got places everywhere else in the town that are falling apart.
Thank you, Doug. We appreciate it. And Joe, Deb, go ahead.
Can I point out too that item C has a non-recurring single event visit, right? And then at the end it says, if you have another single event visit, then you've got different rules. So that seems self-contradictory right in there.
You better not have 2 birthdays in the same month in your family.
There you go. Or weddings, or funerals, or whatever.
So we're all pretty much in agreement that 4C is got to be rewritten somehow or gotten rid of.
Yeah.
Become B, then D. Or move the letters up.
Yeah.
Take a deep breath and move on then.
Yeah.
Well, I think we already had this discussion once, and I don't see that anything was ever changed on this in this article. And that
Okay, so-
was one of the major objections that we heard about last month when we discussed this, that was a problem right along with the permitting the fees and the fact that made you a criminal if you missed some points on your inspection.
Didn't even be on the inspection list. If that's the case. I mean, if you're going VBRO and running it routinely, by all means, that makes sense.
Okay, so if it pleases the planning board, how about we, this could be a good opportunity to send this to our new code revision committee, which I anticipate will be established early in the year, so in a few weeks. And let's do some analysis of the comments that you've provided. I just want to be clear that the comments that I received by email and in the document are there, and they can be viewed by anyone. So they weren't gotten rid of or ignored in any way. I just wanted this to be an opportunity for you to discuss this with Guy, and hopefully this has offered that opportunity. But we do have some candidates for the new position or for the opening in the waiting room. So.
Does anyone have any more comments to make on the short-term rental or questions to ask Guy about it? Go ahead, Guy.
Well, I'll just make the comment that the comments that were made upon the first and second draft of this law haven't been edited. So if you made a comment and thought that should have been removed, it wasn't yet removed because it's still a work in progress and there's not a final version. We were going to do a Q&A, and I heard a lot of commentary. What I didn't hear was any questions. What I heard was conclusions. So that's fine. You can recommend that provision comes out. But that's an awful lot of discussion over a provision that is missing one word as a typo, and a lot of discussion for a provision that's there to make sure that there's no end arounds for having permanent wedding guests forever on your property paying rent. But if you think that people won't figure out a way around this and that those types of provisions are not necessary, then you can recommend it be taken out. There's a lot of changes that could, should, or will be made, but they weren't made to this draft because this draft is still the working draft of the planning board, not something that's quote unquote ready for prime time edited. I've done almost no editing on this thing, although I have made several suggestions. I'm not sure why CJ's note that this is an issue that's been highlighted for really taking a close look at is somehow not good enough at this stage, but it's clear that as a group, you despise 4C and that message has been, it's clear.
We all see, when we look at it, almost all of us are looking at the PDF version instead of the online version with all of the comments on it. So we keep seeing the PDF version because it's linked to in our email. And that's what comes up every time. And when we have discussions, we expect that that PDF version is going to change. And what you're saying is comments are coming right along with it. And we should all be looking at the online version from Microsoft 365 or whatever it is on the thing instead of clicking on the link. I keep thinking when I click on that link, I'm going to see an updated version that's reflecting some of the discussions that we've already had,
Well,
and that's not what we're seeing.
Yeah, I don't know what the process or procedure is that you use as a board for generating these laws and editing and updating them, because I'm normally not participating in that process. But yeah, that's why I decided not to share my screen, because the screen I had was not the version that was tracking all the various comments that were made by email or typed into the document. And I specifically didn't want to create that confusion by sharing the document that I had. So that makes sense. That would probably explain why people aren't seeing what they thought should have been changed. And the answer is the editing hasn't been done yet. It's still a work in progress.
Yep. But maybe we need the link to go to CJ, to go to the Microsoft version online with the comments on it instead of to a PDF version that's keeps coming up to be the same thing. I was confused about that until he just said something, or until you just said something about it.
Okay, sorry about that. It was meant to just link so that members of the public could just see the draft that the planning board was considering. And I wanted to kind of keep your comments here in the document as a working document on the Word version.
And that
so
makes sense.
No worries. I hear what you're saying. I hear that 4C is concerning, and there was a couple other comments that were concerning. So as I mentioned, I think this could be a good opportunity for, it's on its way. It sounds like there's some changes that need to be made still, but it's on its way. And now with the new information from Guy about the Lake Placid case, perhaps it's a good time to just step back and do some analysis on that case as well, and just make sure we're in a really good position. I'm happy to report that the software that I'm hoping the town board approves this coming Wednesday has a module for short-term rental registrations baked right into it. So we're in good shape moving forward, should the planning board want to recommend this. So given the time constraints, would certainly like to open that up to interviews if that's okay with you all.
Okay, let's. Sandy's
I guess
got
I
a
don't
question
understand.
first.
Where are
Wait.
we with this short term then? This is more or less on hold, and we're gonna approach it again later?
Yeah, I would like to send it to the code revision committee, and I would also like Guy to take another look relative to your comments as well as the case that he was just talking about when we first started the meeting.
Come back to the planning board for another review?
Yeah, so we're working out the procedure for how we're going to draft local laws and how they will be reviewed. But yes, I would anticipate the planning board would get to have certainly another look at this before it goes back to town board. So, and there's no rush. I just want to emphasize, we're in December. I think we're in good shape. Moving into the new year, we have all the comments. They're here. They're not forgotten. So yeah.
Sandy, you had a question?
No, I just wanted to mention that Tom and I both sent an email regarding a couple things that we had seen.
Yeah.
Yeah, I have a couple.
Dean had sent a couple things too. Right, Dean had sent a few comments too, and my concern was, when is there a final version with all the comments in the door that I'm supposed to be reviewing, or am I supposed to insert one group of comments and then insert a second group of comments, then insert a third group of comments? When is there a final version that goes for review? And so the better process, and the reason that I was asked to be here, is we'll have one document with all the comments and all the proposed changes on it, so you can go through it and try to get something that's a single document to move forward. But maybe that's not the best process. So that's what a code process is designed to do, to create some regularity so that confusion as to where we are, you're looking at a clean version. We're planning on discussing a working draft. That confusion doesn't exist. Maybe I contributed to it. If I did, sorry, but the document hasn't really been edited yet.
Right.
So I was here to do Q&A because people were concerned about, enforcing the local law and questions like that really did seem like legal questions, but we'll get there.
Are there any other questions for while Guy is here? I don't know. Is everybody else looking at the PDF version or are you looking at the online version?
PDF.
PDFs.
Yeah,
PDF.
we're all looking at the PDF version and we should have been looking at the click through on a link that put us through to the one with all the comments on it. So we failed you, CJ.
No, not at all. In fact, that maybe, my error in attachments and maybe trying to just make sure we're not trading versions back and forth. I had sent a little link in the email that says revised draft, short-term property rental local law. And it's okay. Well, yeah, no worries. Your comments are there. They're not forgotten. And what I will do is take the comments received from Sandy and Tom, and there's this great little feature that allows you to send someone's comment and mention them by name. And so that way you all know who the comments are coming from. And so then Guy and I can go through this a little more carefully. We can go through it with the code revision committee and get a better draft to you, hopefully that's more representative of what you would like to see. So thanks for your patience.
Or maybe we just need to have the same discussion at some point with the document that's got the comments on it, where everybody's on the same page. We're all looking at that document, has the comments on it and links to whatever. I know my comments went up there as unknown user or something because I couldn't log in on it. But, and I don't know if everybody had that problem or if it was just mine. But I think that would be the way to do it rather than sit down and try to retype this whole thing. Just everybody should know that the next time we discuss it, we'll discuss it with the version in front of you that has the comments on it.
Just to address Guy's question and not to go on, but the items I see is collecting a tax, finding out who is a short-term rental, and dealing with disturbance. And if disturbing the peace isn't going to be a law that's enforced anymore, forget it. We'll just go with safety and tax. And whatever people they do. I don't know an easy answer if what's loud's not loud. And we always hear this story about anything. I mean, at some point it changes the neighborhood.
Any other comments or should we move on to the planning report is next on my list?
Okay. Did you have any questions?
Are there any
About this one?
questions on the planning report?
It's kind of boring. It looks like you're just doing one job.
It looks like you're staying busy, that's for sure.
Yep,
Yeah.
but not
Yeah, it's
doing
great.
2 or 3 jobs.
Thank you all. Yes, and thank you, town board. Thanks for bringing John on board. That's been very helpful. Yeah, we are excited to get moving into the zoning in the new year. I know that's on everyone's holiday wish list. And so hopefully we'll be able to move forward with that. And as I mentioned, a code revision committee to be able to bring you, again, as emphasized, a high quality first draft, which I kind of hoped this was, but we're still getting there. High quality first drafts for you to react to and comment on in the future, and a whole wide range of zoning and other land use regulation issues. So I'll look for that coming up in the new year.
All right. If there are no other questions, if there are, bring them up now, or I'll entertain a motion to go into executive session to interview prospective
So moved. So moved.
Second,
And this
Okay, we
recalls
need
a
a
roll
roll-
call vote.
That's right. And so I'll call that. Heather's out
Thank you,
tonight.
Guy.
Yes, thank you so much, Beth.
We appreciate
Okay.
your comments.
Thank you. Okay, so I've got Butler.
Hi there.
Okay, Tom, we're voting on the going into executive session. It's been moved and seconded. And now we're doing a roll call vote.
Hi.
Okay, Conlon,
Yes.
Davidson,
Yes,
Borelli,
Yes.
Sharpstein,
Yes.
Shay's absent. Trumbull
yes.
and Kaler.
Yep.
Okay.